Hey, what's up, guys? What I want to get into tonight is uh, a couple of videos that kind of tie in with the suppression of the search warrant that Ann Taylor has recently came out with. Here's the first video that I want to show while I'm waiting on my special guest to get here.
If you've watched more than
my YouTube course and community, Tube Mastery and Monetization, is 60% off for today.
a couple of videos in this channel, you know about the arguments over search warrants. Search warrants. So the police search someplace and they've got a warrant. Boom, they're good to go. They search someplace without a warrant. And later they argue, so we didn't need one. We didn't need one. But everyone understands that, right? No. Dave sent me a cool article out of techdirt.com. Tim Cushing wrote this. And this is the kind of thing that really makes you wonder. State court tells cops getting a warrant 2 years after an illegal phone search doesn't suddenly make the search legal. So you can't reverse the order of operations. Get warrant, do the search, or do the search, get the warrant. No. The second one doesn't work. It doesn't work. The Supreme Court's Riley decision has been the law of the land since 2014. If police want to search a seized cell phone, they need a warrant. I've mentioned before, if you got time to get one, go get one. Why not? They're always trying to explain why they didn't get one. Well, if you've got the phone in your possession, go get a warrant. Nearly 10 years on, cops are still violating that, though. The inability to follow the rules is seen evidence in a criminal case tossed twice. The first time it got thrown out was back in 2022. And the Georgia Appeals Court wrote, the record shows that on November 10th, 2020, police executed a search warrant for this man's residence. The warrant authorized the seizure of a number of items, including digital devices such as smartphones. Now you think, okay, well, they have a warrant. The warrant did not authorize a search of the contents of those devices. During the execution of the warrant, the cell phone was taken from the man, later given to a detective who was asked by somebody else to extract digital data from the phone after being told that the police had seized it pursuant to a search warrant. So there was a warrant that said you can seize this stuff. And some people would say, but Steve, come on. If they say you can seize it, you're telling me they can't search it? Well, remember that quite often search warrants are quite broad in what they describe. And it might say you can go into this business or into this house or this residence and seize cell phones. Well, what if they go in there and there's 7 people in there and they each have their own cell phone and 3 of them are visitors from another country and have nothing to do with the story? You seize their phones. Okay. Do you get to search them? Well, that might be why you need to go to a court and say, okay, we need a warrant now to get into these phones here. Okay, do you really need to search the phones of the people from the other country who've got nothing to do with the story? I'm just, So the detective explained during a motion to suppress hearing that he was not limited in any way in searching the cell phone contents because he believed a valid search warrant existed. He further stated he would not have searched the phone if he had known that the initial warrant did not authorize the search of the phone. According to the detective, there were some discussions with the assistant district attorney and or case investigators regarding the evidence downloaded back in 2020. So their first argument was, well, we didn't have a warrant, but the guy who did the search thought he had the correct warrant. He thought, is there some kind of good faith exception in the Constitution? Quick, go read the Fourth Amendment and look for the phrase good faith. You don't have to. Meanwhile, the man was charged with a variety of crimes, with the state asserting 2 years later that the phone contained evidence of a robbery.
Now, what do you have to say about this, Kiki?
Sorry, forgot to unmute myself. Robert, first off, thank you so much for having me on tonight. I really appreciate being part of your panel. I think that you're picking the most relevant subject to talk about right now. And this is really interesting because he talks about this good faith clause. And I think that's kind of what we're all feeling is, we hear one side saying, well, are you saying that we can't trust the police? And I think the other side is saying, no, we're talking about procedure. These are our constitutional rights. You don't want somebody to go back after the fact and write a warrant. And this is the way he's explaining it. He also says that there's some sort of tainting of the warrant process when you write one and then you come back and do a second one. They talk about cutting and pasting in this video because you had me review it earlier. I don't know. I think this is such a relevant video to the subject matter we're talking about when it comes to Brian Koberger.
Yeah, because I mean, if you look at it, with the different the suppression, the motions to suppress, it states in numerous of them that Mallory was copying and pasting from Blaker's affidavits. So and I watched this video a couple nights ago, and I felt like it tied in with the motion to suppress the search warrants because, like you just stated, they're talking about copying and pasting. Well, if you read some of the suppression motions from Ann Taylor, they're talking about Mallory copying and pasting some of Blaker's affidavits as well. So,
and I actually want to bring up one more point that he's touching base on right now is he's talking about a situation where there might have been a couple people from another country staying in a house where a search warrant was executed, and it says they can seize cell phones, but it doesn't say you can seize the content within that cell phone.
Yeah.
So my thought process when I heard him talking about that earlier was thinking about when they executed the warrant on Brian Koberger's parents' house, Pennsylvania, in Pennsylvania. There was a common area where they had an iPad and several other things. And the scope of the search warrant didn't cover that. But later on, apparently they obtained, I would assume, another search warrant via the FBI to get that and the content within it. I don't know. It's just interesting. And I thought for those that were wondering about that, because that kind of is something that stuck out when we were reading these motions to suppress, he kind of touches base on how that works. But I don't know.
Even when they raided Brian Koberger's parents' house, Brian Koberger's phone was in his room, and the one of the FBI agents that raided the house decided to pick the phone up and go through it. Now, with him doing that, wouldn't that be an illegal search of a phone without a search warrant?
I didn't quite catch. So the police went through Brian Koberger's phone without a warrant at the house? Is that what you're saying?
When they did the raid on his parents' home,
yeah,
his phone was in the room, in his room,
mm-hmm.
And either the ISP officer or the FBI agent saw his phone, picked it up, seized it, and then searched it.
And that's described in the motion to suppress?
Yes. And it's described in the motion to suppress about Brian's. And there's one motion to suppress about Brian's phone where it stated that one of the arresting officers found his phone in his room and seized the phone and then searched it in the room.
So that's even more perplexing to me, because when it comes to the cell phone, the warrant gets like super specific. And in Andrea Burkhart's live a few nights back, she really touched base on this. So essentially, if you suspect there's a crime, you have to issue a warrant for the specific piece of data you want on the phone. Like if you think that it would be in the text messages, you have to have like a text message specific or specific to the gallery of like your photos. You can't just say, I need a warrant to the phone and you get to look at everything. And he does touch base on that. I mean, this guy does an excellent job talking about it, but I know in the breakdown, at least of the phone, you wouldn't just open a phone and say, okay, I have a warrant to search. You would open a phone and say, you would get specific, and you wouldn't do it through the phone. you do it through like AT&T.
Yeah.
Or like that's all like that.
Hey, too fast.
So he moved to suppress the evidence, and the trial court granted this motion in May of 2022, pointing out the terribly obvious. The search of the man's phone was unconstitutional due to the lack of a search warrant. So, sensing things weren't going their way, the government belatedly tried to salvage the evidence. On April 26, 2022, while the motion to suppress was pending, the state applied for and obtained a warrant authorizing the search of the cell phone. And the same detective again downloaded the contents. The state acknowledged at the appellate level in their brief that the detective used the same protocol, same procedures, and same forensic extraction software when he extracted data from the cell phone in 2020 and in 2022. So they said, okay, we'll pretend we didn't do the previous search and we'll get a warrant now and do the search. And of course, the reason they're in what we call a hell-hot hurry to do the search is they know there's stuff on there they'd like to have, but they've already tainted it by extracting without a warrant one time. The detective testified during the suppression hearing that extractions done in 2020 and 2022 were basically the same. Even the prosecutor admitted to the trial court that the information extracted in 22 mirrored that extracted in 2020. Well, of course, that's not how things work. The appeals court says you can't salvage a warrantless search by acquiring a new warrant 2 years later. That's what the lower court said too, resulting in the state's attempts to have that ruling overturned. Imagine what would happen if the state, the government, police, whatever you want to call them, if they had the power to do warrantless searches, see what pops up, and then apply for warrants after the fact. Why not? It kind of reminds me, if you work at a 7-Eleven or a gas station that sells scratch-off lottery tickets, just scratch them all off and buy the winners. Why not? I think that's a valid parallel. Based on these findings, the court granted the man's second motion to suppress, concluding that the 2022 warrant was obtained solely as an attempt to overcome the constitutional violation which occurred in 2020, of which the state became concerned after reviewing defendant's first motion to suppress. Allowing the state to get away with this would make warrant requirements irrelevant. Without the deterrent of losing illegally obtained evidence, cops could just search first and get warrants later. That's what happened here, and the existence of a warrant 2 years after the fact does nothing to make the first search any less illegal, nor does it make the second search any more legal, in case you needed to have that clarified there. Independent discovery doctrine argument fails. Court points out that the state copy and pasted most of the new warrant affidavit from the old one that did not give it permission to search the contents of the phone. The original warrant only permitted seizure of the evidence. Using the same facts to acquire a new warrant permitting a more intrusive search doesn't impress this court any more than it impressed the trial court. And the detective can't rely on the good faith exception to excuse the first warrantless search because there is no such exception under Georgia law. And the court wrote, we likewise reject the state's suggestion that the good faith exception should apply because the detective believed he had authority to search the phone in 2020. Georgia law precludes adoption of the good faith exception to the exclusionary rule as part of the jurisprudence of Georgia. Despite the state's suggestion, this court is not at liberty to overrule a Supreme Court precedent. I mean, they could, but what happens is they go up to the Supreme Court who'd spin it around and send it back down again. So there goes the evidence for the second time. Court of Appeal says the same thing the lower court did. You can't undo a constitutional violation by trying to be a bit more constitutional 2 years later. We'll see if the government learns from this experience. If nothing else, it might want to put together some remedial constitutional law classes for its investigators and prosecutors. And so Tim Cushing wrote that for techdirt.com. It's a wonderful article, and it's a fascinating case, and it's so painfully obvious
This is the premium Garmin Duffel 45-liter by Half Day. It's a transforming 2-in-1 travel duffel bag for long weekends, weddings, and business trips. The hanging compartment
that you wonder, okay, the prosecutors and the police are fighting this, really? On the theory that we did something wrong by doing a search without a warrant, and we went and got a warrant after the fact to authorize what we've already done. And you can see the glaring mistake in that logic. And I was talking to my brother on the phone yesterday, and he reminded me of something that we often joke about. And there was an old comic strip called The Wizard of Id. The Wizard of Id. And it's kind of hard to describe. If you're not familiar with it, look it up. Wizard of Id, ID. And it was syndicated nationwide. And there was a lot of stuff in The Wizard of Id set back in some mythical country hundreds and hundreds and hundreds of years ago. And in one of the panels of The Wizard of Id, there's a couple like barbarians or Vikings, or I don't know what you want to call them, but just a bunch of guys standing around with like spears and clubs and torches. And there's their leader talking to them. And there's just the smoking ruins of a village they've apparently just burned to the ground. And he has them repeating after him: pillage, then burn. Pillage, then burn. The point is that if you burn the place down to the ground, you can't get the stuff you wanted to pillage because it's all gone now. So you pillage, then you burn. And that's this case. Search warrant, then search. Warrant, then search. Seriously. And I've said this before in other videos where somebody goes into court and makes an argument. And I've heard some dumb arguments in my life. I've mentioned a few of them in videos I've done. But when somebody comes into court and says, okay, we illegally searched this phone on this date, but 2 years later, we got a warrant that authorizes it. First question I would ask is, what judge signed that warrant? And did you disclose that you'd already performed the search that you were looking for a warrant on? And if I was a judge, I'd actually go call the other judge. Go, did you know this? Did you know they're asking you to, in essence, authorize a search that had already been done? Did you know that? And they're going to say, well, no, we did a second search, identical to the first. Just like Henry VIII by Herman's Hermits. Second verse, same as the first. So this is a crazy case. And it exposes, I think, the mental acuity, shall we say, of some of the people who work in law enforcement in Georgia. But it's a crazy story, but it has a good ending. So state court tells cops getting a warrant 2 years after an illegal phone search doesn't suddenly make the search legal. TechDirt.com. Tim Cushing wrote it. Dave sent it. Thanks a lot. Questions or comments, put them below. Let's talk to you later. Bye-bye.
Thank you for watching.
Well, Miss Kiki, what'd you think?
I have so much to say. So I think that initially this was, well, what I learned from Andrea Burkhart's live the other day, this was a concern initially by our forefathers because they had seen in other countries. I'm sorry, were you going to say something?
No, I said, yeah, I was agreeing with you.
And they, she brought up that previously before our Constitution in England, the king would authorize searches of homes, and it was a huge privacy issue. Just like you were talking about with the cell phone, it wasn't specific. And so this was a huge concern of our forefathers, and that's why they put it in. And what's interesting is he talks about the good faith clause, which is something they give a little bit more they give a little bit more trust to a police officer, a law enforcement's word. And so they're saying the good faith clause doesn't apply to search and seizure because there's no good faith clause in the Constitution. And I thought that was a really intelligent argument that he made. I really hadn't heard before. And then he also talks about how when you have a previous warrant and it was incorrect, if you went back and corrected that warrant or reapplied, it kind of makes the extraction tainted. And the reason for that is because you need to have, law enforcement needs consequences when they don't perform it right. They have to be able to lose the evidence. There has to be a consequence for not performing this search and seizure. And ultimately, he's also saying, like, if this was done correctly, if you do see this, he's saying that it goes back to the judge. Like, even if it's another judge, like, you should contact the initial judge and say, hey, did you know that they were, using a previous search warrant or cutting and pasting? And I mean, I don't know where the consequence is there. Like, is there a consequence? Who watches, the watchers?
Yeah, I'm seeing it, and it all goes back to, like he was talking about cutting and pasting, and it goes back to Mallory, who was cutting and pasting from Blaker's affidavits, and we've all heard, what's his name, Brett Payne, state that he likes people. Yeah, he goes to people who's smarter than him to have his work done for him, and we've heard Dawn Daniels saying that she's going to do the search warrant without using the DNA because she thinks the DNA is going to get thrown out. And this next video I'm pulling up, it actually talks about probable cause and search warrants. And, the one thing that,
I was going to say, like, back to what you were just saying about Payne, and he relies on people smarter than him. We did like a segment on a live stream about a week ago, and we actually talked about his background. Payne is a really smart, experienced officer, and it makes you wonder on the stand, is he being coy? Is he, just speculating? Or is he playing dumb? Just throwing it out there. But if you look into his background, he has a ton of experience. And I didn't mean to interrupt you.
Nina says, Dawn Daniel used DNA in search warrant, not IgG. I just said that, Nina. Dawn Daniels didn't use the DNA in the search warrant, and she has stated that she wasn't going to use the DNA to get the search warrant because she thought the DNA would get thrown out.
Like the rhetorical paragraph, if this is not exculpatory, then use it for evidence. But if it is deemed exculpatory, don't use it for evidence. I don't know. Like, if it's deemed that it can't be used as evidence and you're putting it in there and it's not evidence, isn't that inherently to create, just speculating here, bias, right? I don't know.
Nina said, ask you, she did use DNA. Dawn, she's a Dawn Daniels did use the DNA. She said to ask you.
Wait, what are we saying? Let me read her comments. Dawn Daniel used DNA in a search warrant, not IgG. Okay, so she, I'd have to. I would have to reread the search warrant because the only clause that I don't remember seeing the DNA reference. I do remember hearing the IgG reference, but if she added so many pages to it, I honestly don't know where she references that. Yeah. But if she does reference the DNA, I mean, I take back what I said. Maybe you could send me that page, Nina, and I'll review it really quickly in Discord. I don't know. Sorry.
PC search of a vehicle doesn't equal PC to search of a person, right?
Right.
And that's the motor vehicle exception. The motor vehicle exception applies to containers, not to human beings. Now, the cop says occupant is in the vehicle when PC to search is established. The occupant refuses to consent to search of his person and refuses to consent a pat down. Now, there is no reasonable suspicion for a Terry pat down. You visually notice that after get him out of the car, which of course we can do, you can see a wallet in his pocket. The question for you, Mike, is this: does the officer have the authority to enter that pocket to retrieve the wallet and search it under the motor vehicle exception?
No, not without a nexus. And where does this come from? Like you said in the question, there's you can search containers with probable cause, and we'll take a quick step in looking at the automobile exception right there. Probable cause, right? Fair probability that evidence is in there, fruits are inside the vehicle. All right. Apparently mobile. Mobile. I don't know why I said it like that. Mobile.
Mobile. You've been.
Mobile. I was in the Midwest this week, so I got my twang back. We talked a little bit earlier. It's not on curtilage or curtilage, and it's the scope where where would a judge allow you to look for what it is you have probable cause inside this. That's just kind of a quick summary of what we're looking at for what we got to have for it. But the question is, can we search passengers automatically because we have the automobile exception? And the answer is no. You've got to give me some sort of a nexus, a justification of why this person, you've got probable cause for this person, they have evidence on them.
Now, look, I mean, I think that I think the way to say this is that people are not containers, and the motor vehicle exception applies to the vehicle and any containers they're in. But a person is not a container if the wallet is in their pocket. It is not a container. Let me give you, I don't know the case name. It doesn't really matter, but I'll tell you what they said. If a container is sitting on its own, it's searchable under the motor vehicle exception. The problem is that wallet is not sitting on its own. It's in his pocket, right. And that's why it's not a container under the motor vehicle exception. I've also seen a case where the guy had a fanny pack, which, have you noticed that fanny packs are making a comeback?
Oh yeah, it's quite all the rage with the youngsters these days.
I'm being serious. Are you being serious?
Well, you got the fanny packs, or I guess the new is the
sling bag.
Sling bag, or the crossbody, or whatever you want to call it.
Look, I'm cool. I have a sling bag, right? But I'm telling you, Mike, that two things are making a comeback in our society, which kind of proves the degradation of our society. Okay. Number one is fanny packs, and number two is mullets. Mullets are coming back. Have you seen mullets come back? Oh, your department might be a prime violator right there. Okay, right. The business up front and the party in the back. Now, I wish I could grow a mullet.
No, you don't. No, you don't.
I wish I had the capability to grow a mullet.
Okay.
All right.
Well, I was in the Midwest, and there's a bunch.
Man, they love their mullets there, man.
But they never went away.
No, they never got the memo that IROC Z28s and mullets were actually not an in thing anymore.
Exactly.
All right. So back to our thing here. So the fact is, they're not sitting on its own. Now, an officer brought up Anchondo. What do you remember Anchondo, or do you want me to kind of get into it?
Yeah, well, I mean, the biggest thing in Anchondo was the driver.
Give some facts though. There are many people that have no idea what you're talking about. What's on
somewhat near the border, correct? And stop was made near there. They developed probable cause to search. Was it by dog, I believe?
Well, they had reasonable suspicion. They run the dog around the car with the people in it. Mm-hmm.
Then get our PC, step out, and was it Anchondo who was the driver? Which when we look at this, is usually a far less burden to show that nexus. Your drivers are in control of the vehicle; they should be aware of everything inside their car. And I think Anchondo was one of Anchondo's statements as well. You're not going to find drugs in that car. I think it was after they searched it, or was it before or after? I don't remember.
Twice. No. I'm sorry. It alerted twice. The dog alerted twice. They searched it once, and while searching and not finding anything, Anchondo, the driver, said, "You're not going to find drugs in that car."
Yeah, which again, we talked earlier about building a nexus. He's the driver. There's the PC hit by the dog, and a statement like that is like, "Hey, you're not going to find him in there."
Yeah, probably on me. So I think the point is that, look, Anchondo seems to be a viral case when it comes to searching passengers, right? And I think it's because there are some instructors out there that are, I believe, we're all allowed to have our opinion. I believe that some instructors out there are misinterpreting what the court is really holding here, right? And I don't think Anchando should stand for the proposition that if you have probable cause for the vehicle, you get to search those people who are in it. If that's the case, then get probable cause for a Greyhound bus and start searching other passengers. I know I'm being extreme, but it also is the same thing for an Uber. It's the same thing for me and you, Mike. Mike, we are good friends, okay? And you know that I don't do drugs, but you don't know, you're not 100%. I mean, maybe I do drugs. And if we're the answer is no. But if we're in a car and the cops find probable cause that I'm doing drugs, okay, and they start searching my car and they find indicia of drugs under my seat and my backpack, why in the hell are they going through your pockets? You don't do drugs. You're not going to be nervous. You're not going to be running. You're not going to be lying to the police. You're a good person. And so just because
me,
huh?
You're saying there's no nexus between those drugs.
There's no nexus, as you said. So boom. All right.
What was it? So was the Dry case or whatever it was? It talked about like just being a passenger in the car doesn't strip you of that Fourth Amendment right, or that Fourth Amendment protections in there, right?
Yeah, that's right. That's right. So you want to look at the 1948 case of U.S. versus Dry, where the Supreme Court said essentially that the Carroll Doctrine from 1925 does not apply to passengers in vehicles. And in a nutshell, in that case, the police had probably it was a World War II case, so it got decided during World War II. In that case, the police had probable cause that there was illegal or forged gas rations, right? Right? Gas rations, because that's how you only get 5 gallons a week type stuff. And he forged them and he was selling them to get more gas than you deserved, or not deserved, but you were allotted. And they searched the car, they found the gas rations, and then they searched Dry, who was simply a passenger, and the U.S. Supreme Court threw it out.
Oh, Miss Kiki, what do you have to say about that? I think you're muted.
Sorry about that.
Right.
So I do have the part to the 166-page search warrant, the one that Daniel's applied for, and I have that page. The only thing I will say is I don't see in you all. We can read the whole thing. It's not very long, but there's a ton of interesting points in this section of the search warrant that I'd love to talk about. But what I will say is this: I don't see the word DNA on it, and I could be mistaken. We'll just read it and find out. I read it while we were watching that. But what I will say is this: is that when we talk about DNA, let me just turn off the Discord. They touched base. They were talking about when you search a car and you can't just go searching that person. Well, they touched base on something that applies to this case, which is the curtilage, and that's something that, again, Andrea Burkhart talked about during her live. And so she says that in all of these documents since the beginning of this case, she's seen hinting or language that has kind of like hinted at this curtilage. And essentially what she's saying is, like, when you search a property, they're assuming the trash that they collected that DNA sample from was fair game, because once you dispose of your trash and put it on the curb, it's fair game. But she's seen language that might say that it violates this curtilage part of the search warrant. They didn't have the right to obtain it. And I wonder if that's what you mean, Nina, when you say she used the DNA, because they used the buccal swab to obtain that search warrant versus using the IgG.
Now, I do have and I've been thinking about this the last couple of days. I've read the motions to suppress, and I'd like to know if the FBI was really interested in this guy, as well as Moscow Police Department. Why didn't they take his DNA out of the neighbor's trash instead of taking his dad's? If he's being surveilled by the FBI and the FBI is watching him put his trash in the neighbor's trash can. Why didn't they take his trash out of the neighbor's trash can instead of just taking his dad's trash? Yeah, just like they viewed him, they surveilled him, running and hiking around his parents' neighborhood. If they really wanted to arrest him, why didn't they arrest him when he was out on a run or out on a hike? Why did they wait until he was in his parents' home and destroyed his parents' home? If they really wanted him, they could have arrested him away from the home.
Well, I mean, I can't, all of these questions, I have the same ones, Robert. I'm glad you're bringing them up, but I will even go a little bit further when it comes to the trash. My question is, why didn't they call him in for questioning while he was still in Washington? When they had their eyes on him, why did they not ask him to donate a sample of DNA like they did the other people that they cleared at the beginning of this case? That's just a question that I personally have, because for me, when I think about if somebody is suspected, and again, these are just questions. This is just speculating or wondering. But as a citizen, you think, okay, if you're suspecting someone of a quadruple homicide, and you're not even going to call them in for questioning, and you're not going to ask for a sample of their DNA. And the other thing I think of is they're traveling from Washington to PA, and we saw the what's so-called drug interdiction stop, or what could have been something staged by law enforcement or FBI. However,
that's what I've been thinking.
Yeah, me too, because I saw a video of Indiana State Police pulling over. Someone, Meg, sent it to me in Discord, and it was totally different. And the way they operated their body cam was different than in the stop with Brian Koberger and his father. So all I'm getting at is if they had any eyes on him, if they were following them at all, why at the restaurant or the hotel or any of these other stops were they unable to obtain some sort of DNA sample? I don't know. And then oh, I'm so sorry.
Go ahead. Go ahead and finish your thought.
Well, the final thought I want to say is just in response to your initial statements. That is another question I have too. Is it does kind of feel like it was for shock and awe when you hear that they raided Brian Koberger's family's house in a way, because the actual documentation of him includes that he goes jogging. You know, why would you? And again, I'm just asking because I don't understand. I'm asking the audience, not, coming down the police, but it's like you're kind of putting 4 innocent people's lives in danger. And I understand the danger of this person, but you don't have to put more lives in danger if he goes out jogging every day, or if he goes to the neighbors to drop off trash, or if he's seen in shopping centers with gloves on, or like, didn't he go get some work done on his car while he was in PA?
And as a matter of fact, they have him on camera walking into an Albertsons like a couple of days after the murders. I mean, if they were really watching him after the murders, why didn't they ask him to come in to answer some questions, or ask him for some DNA, or ask him for this, or ask him for that? Why did they not? If they were really onto him, like the Gonzalez family said that they were, if they were really onto him, why didn't they ask him to come in and answer some questions and get DNA and get this and get that? Why let him drive 2,500 miles across the freaking country, and then just have the FBI sit out in front of his parents' home and watch him?
I have no idea. I have no idea. I'd like to know in the audience, can you think of a reason why the police wouldn't call him in for questioning? I mean, it doesn't appear they were collecting more evidence. The one thing we know they were doing research on was getting the IgG, or actually, I don't even know if they were getting the IgG. I don't know if that was the nexus that led to Brian, or if it was the Elantra. But what additional work were they doing that it would, you know what I mean, wait to, I don't know. Did they not have nothing to work to? Like, why didn't?
Yeah, I have something about the car. I have it pulled up from one of the suppression motions. Pennsylvania law enforcement violated Mr. Koberger's Fourth Amendment rights by entering and searching his vehicle without a valid warrant. Police cannot search a vehicle within the curtilage of a home without a warrant. Collins versus Virginia. And Mr. Koberger's vehicle was in his parents' garage in a home where he was an overnight guest. Overnight guests have an expectation of privacy in the home where they stay. Therefore, he had an expectation of privacy in the contents of his vehicle, and a warrant was required. Pennsylvania law enforcement search warrant lacked probable cause. What do you think about that, Kiki? Their search warrant lacked probable cause. They see his car in his parents' garage, and we talked about curtilage. Yeah, and they seized the car. Then they went through it. After they seized the car, did they get a search warrant to go through it, or did they just go ahead and go through it without the search warrant, then get the search warrant?
Well, I believe it was a separate search warrant because the receipt, I saw the receipt for it. Well, I do know it was a separate search warrant. I don't know if it's all included together, but it had a separate receipt and it had to be left with the car, which brings us back to Dawn Daniels and her execution of the receipt, which brings back to the language of that second video we watched where they're talking about the taint extraction and the consequences for doing that. But we know the way the Dawn Daniels receipt worked, and I have that document too, pulled up in the background when you're ready for it.
Here we go.
All right, let's read from the book of Dawn Daniels here. Okay. All right. So I'm going to stop at a few places, but I think I'm going to zoom in a little so you guys can see that better. Hold on. Let me check StreamYard. Yeah, that's a lot better. Okay. Okay. Sorry about that. Oh, hold on. Okay. I, Dawn Daniels, Assistant Chief WSU Police Department, declare that I have personal knowledge of the matters herein and or am relying on witness statements, information provided by my fellow officers, including fellow officers from the state of Idaho, reports, and other material I have gathered in my investigation, and that I am competent to testify to the matters stated herein. On the basis of the following, I believe there is probable cause that Brian Koberger has committed these crimes of murder, first degree, Idaho Code IC 18-4001, 4002, 4003, 4004, and burglary IC 18-1401, 1403 in Moscow, Idaho, and she's checked off the box for evidence of those crimes. Is located in, on, at, or about the following described premises, including premises, vehicle, or person. So this includes the vehicle in this, if it were there, which it's not. The office is inside Wilson Short Hall on WSU Pullman, Washington campus. The address is Wilson Short Hall, 1475 Glen Terrell Mall, Pullman, Washington. Probably shouldn't be reading that out loud. I'm not going to read these girls' names out loud. I mean, they're displayed here. But it's really interesting, and this is something that I've brought up in previous videos. This is a little bit off subject, but I think the audience will find this particular focal point or this particular talking point quite interesting. But if you look here where it says, Wilson Short Hall is a multi-story brick building housing multiple offices. The office to be searched is number 12. Number 12 is a student office shared by Kohlberger and 2 fellow WSU students, we'll just say KXC and NK. It is on the ground floor and it has a number 12 on a placard next to the door. And it has 3 names on a piece of paper taped to the door, of which is Brian Kohlberger. What I wanted to point out is this: there's several interesting things that kind of push back on the mainstream media narrative we've heard about Brian, and possibly might debunk a few things that we've heard in mainstream media about Brian. The first one is, Robert, if Brian Kohlberger had lost his job, and remember, it was suggested that he had lost his job like a week prior to this in a disciplinary action. Why would his name still be handwritten on a piece of paper with his 3 office mates and taped to the door? I mean, it's not even the placard that says his name. It's like literally a piece of paper taped to the door. Like, if he had been let go, you would think that that piece of paper would have been torn down by one of his office mates. It's not like a permanent fixture. It's just interesting. And the fact that the possessions of his office were still there, because they say that the day before that's how they knew that. They walked through to make sure he was still, employed there. That's how they knew about that, to put it in the search warrant. They didn't, you know what I mean? Like, you don't know there's a piece of paper taped to the door unless you, like they said, go there the day before and look. And so it kind of pushes back on that narrative. I wanted to say that. The other thing I want to say is this, finally putting to rest, we hear of this incel theory, or someone who can't work alongside females. And this is another example where that we don't really know where that theory came from, because his 2 closest office mates are females that he works closely with. And one of them has been I have sound bites of this, allegedly one of his office mates or somebody else that he works with being seen out front of his apartment. And just the fact that it's not just this example. Back at DeSales University, he was in very close quarters. Same thing, not when he was a teaching assistant, but when he was getting his PhD, working closely with other women. So I thought that was interesting. I wanted to pause there first and just make a couple comments about that. Did you have anything you wanted to say before I kept reading?
Well, here's the thing, though. If he was actually quote unquote fired or let go, while he was like on his way to Pennsylvania for the holidays, his name would have been taken off the door, and those other 2 names would have been left on the door. Yeah, they would have typed up a new piece of paper and with just the 2 female names on it, if he was actually technically let go. I don't think he was let go. Maybe he was let go after he was arrested, but I don't think he was let go until he was arrested. Because the KXC and the NK, their names would have been the only names on the door. If he would have been let go before he was arrested.
I couldn't agree with you. I couldn't agree with you more. I mean, just logically, that seems what the answer would be. And I mean, think about his office mates going in and out of the door. If he was let go for disciplinary actions, the allegations, and first off, the allegations that we heard, I want to remind everyone, the way that we were reported on it, we shouldn't necessarily, I mean, it's up to you what you believe. But in this situation, I've read this article and I've tried to source it back about the disciplinary actions towards Brian. And there were some concerns, but we don't have enough people coming forward to back up that story. There were, in fact, part of the people who came forward in the New York Times, they said the incident they had, Brian was completely clear that he done nothing wrong. And the one person who stood forward and said that there was some sort of disciplinary action, they were supposedly part of a meeting with people who were part of the teachers union. It was part of a confidential meeting. Like they would have been risking their job to leak it, and it's only one person, and you're not supposed to go with one person for a source when you're doing an anonymous source like this. But nobody else would back up the story. So I just don't even think there's any. I think the story, it appears to be fabricated at this point.
Yeah. Just like Janet says here, Brian was still employed by WSU when he went to Pennsylvania. He was not officially separated from WSU until mid-January. They put that on an official statement.
I mean,
So he was not fired until he was not let go or fired until he was arrested.
Yeah, until he was arrested. And I've heard, and I don't know if it's accurate, and it doesn't necessarily mean anything, but I've heard his email was actually active until like mid-January, kind of like what you said. But I've heard other people also say IT departments are like extremely slow to get rid of old email addresses then. But the person that was talking about it said that she could go back in and read her emails that she had back and forth with him in their student portal. So it was interesting.
You know, what's really interesting is the search warrant for his for YouTube. So does that mean he possibly had a YouTube channel?
Yeah, I would say I'm not 100% sure, but I would say I'm pretty confident that the Ezra account could possibly be real. And I'm probably at about 85%. Now, what that means for maybe someone who aren't familiar with that email address, if we go back to the original email addresses that people were affiliating with Brian, a lot of them were fake, which caused a lot of us to believe some of the content we were reading was fake too. The Ezra account, the email that is kind of affiliated with that name, it was obtained through a data breach. It was a little bit different than the other ones. There was a data breach with some sort of, I don't know if it was like a credit counseling company or something along those lines, but that's how that email came out. And all I was looking for was some sort of validation of anything affiliated with that email. And I feel like I got one from, I can't remember the kid's name, but his last name, I believe, is Ernst. It's Ernst or something, ARUNT, something like that. But his sister was the same age as Brian, and we've seen pictures of Brian and this woman. I guess he came back for like a wedding or something like that. And we've seen pictures of, well, her little brother apparently confirmed to the New York Times that Brian Kohlberger did talk about his visual snow. And so that's kind of the only way we've confirmed that Ezra account, is that he kind of confirmed those visual snow posts, but he's just one person, and he does appear to have known him. So I don't know if the Ezra account is real. If the visual snow is real, it would also mean that YouTube account and that BK's rap was real. And I'm going to be honest, that rap, if you know what he wrote in the Taps to Talk form, it 100% sounds like it was written just like he said. He was writing it about his fellow visual snow sufferers and what they go through. And your thoughts, Robert?
Well, I didn't know the big bad BK was a rapper. but no, just it feels like it was, with suppression, the motions to suppress. When you read through it, it almost feels like that the law enforcement jumped the gun. Because if you look at it, Kiki, if you really look at it, the Moscow Police Department was in way over their heads, well, with this murder, with these murders, because they have not had anything like this happen in that town for a long time. And I mean, I don't want to agree with Steve G or anything like that, but maybe Steve G was right. Maybe they were in over their heads. Because look how sloppy everything was. Look at the coroner, Kathy Mabbitt, stating that they were all stabbed. They were all stabbed in their sleep in their beds, when clearly that wasn't the case, because we've heard that Xana had injuries by an edged weapon, and we heard that Ethan had sharp force injuries, and we heard that they were all asleep when that wasn't the case. You had Xana awaken on her TikTok. Xana had a DoorDash, and Matt, of course, Maddie and Kaylee, they were stabbed to death, but the other two weren't. So I do not trust anything that this coroner says, because I felt like she had lied to us from day one about how they died, about how they were found, and clearly, you have two roommates that lived through it. But why didn't they call 911? Right after Dylan, quote unquote, saw the killer. 5'10" or taller, clad in black, bushy eyebrows, athletically built, not muscular. Why didn't they call 911? And everyone knows how. Even Brett Payne stated when he walked into the house, as you walked into the threshold, you could smell the blood. So how come these two roommates that survived didn't smell the blood? You're muted, Kiki.
I don't know. And then there's like all these other layers of complexity that we keep adding to the things that you're saying, like having the door open at 8:30 in the morning. And how does that play a role in when you talk about the coroner and the time of death? And yeah, I have questions about the 8-hour time delay, but I also wonder, how was like no distress call me that night? Not just saying the surviving roommates, but from the actual victims. And were there other things? Were there other forces at play? Was there something going on with their alert systems? Was there any interference? We hear Syray talking about a Stingray device. Was there a Stingray involved? Did somebody try making a 911 call that got dropped? Did just these different things. Just trying to add to what you're saying.
Yeah, and I've been reading the last couple of days. I didn't even know there was a pen trace involved in this when it comes to Brian.
The pen trap trace?
Yeah.
I've just come to understand that, but what are your thoughts on that? And I do see some really good comments too.
There's that one. I just read that one. Okay, I don't believe all these people who crawl out the woodwork with stories for their 15 minutes of fame.
And I'm totally on board with you, Jana. And this was the one instance where I'm like, well, they've gone on record. They've gone on record saying this. They do have actual photos. But you're right. Like, they're not the only place I've corroborated that visual snow with an actual person is because of that little brother. And then what you were saying about him being an aspiring rapper, like that totally is taken out of context from what I've studied, if those tap to talks are real, because he was only 15. The first thing is, so I mean, when you hear it, it's not like we're listening to a man, listening to a teenager. Not too sure on this, but can you legally drive a motor vehicle if you suffer from visual snow syndrome, as your vision would be impaired unless you have special glasses? That's a great question.
Yes,
and
it is.
Puts validity into it. Puts question into the validity of this witness, you know, who says that it's real. And we know about media bias too. Could he just remember something? He didn't go into great detail, and he just barely references it in this article. I wonder, is there confirmation bias or media bias? I don't know. I wish there was more detail about it.
Yeah. And just like this one, Paul C. How do all these officers know of Brian and obtain warrants, and the investigating officer never know of him or start his investigating of Brian and the car until the 19th of December, as he stated in court?
Wait, can you keep displaying Paul's comment for a second? I just want to. Okay. How did all these officers know of Brian and obtain warrants in the? I don't know. And did they know about him before then?
Yeah,
and Paul, it goes back to that thing. Like, if they did know about him on the 19th, wait, you said the 19th?
Yes, December 19th.
So they left on the 15th for
yeah, they left on the 15th for Pennsylvania. Now, I do know that the reason why they went through Colorado is there was supposed to be like a really bad winter storm coming through Montana and Idaho. So him and his dad wanted to avoid the weather, so that's why they took the southerly direction through Loma, Colorado.
Okay.
But I still think those two stops by the Indiana State troopers were controlled stops, because if you look at it, you know, the first stop, he was pulled over for what? For traveling too close, basically tailgating. They let him go. 2 miles down the road, he gets pulled over for the same thing, tailgating. So, is that a controlled stop or not?
I mean, like, I've seen the footage, and like, it goes both ways. I've reviewed the footage with people who say, oh, it's obvious he like sped up and like got too close to that car. And then I looked at it from my own eyes and I didn't think so. So I don't know. What are the chances? But they were just like many people have pointed out, it fits the profile of a drug interdiction stop. You're right. And also when you see the body cam footage where it like really looks into the car, and you don't see that in other examples of body cam footage we see from Indiana State Police. And
there's Nina's 4 warrants: fugitive justice warrant, car search warrant, house search warrant, and person search warrant.
If we keep that comment up, so and I know I keep going back to Andrea Burkhart, but she did such a thorough job reviewing these documents the other day. But this is an interesting thing too, because apparently to her and probably other people who are really interested in the law, this becomes kind of a tricky thing, because which privacy clause trump others? I mean, when warrants come in and they're being issued by other states, seeing who's in charge of what and what order they come in, I guess there's valid legal arguments with that. And the challenges that they make are a little bit complex, and I don't quite understand them, but they are saying that this could have been the wrong type of warrant issued. And I know these are all technicalities, but this is Ann Taylor's job, and our justice system is only good as the people who run it. So we have to look at all these things.
Yeah, and I agree with you. And just like I Am Lex said here, they can't establish probable cause with the evidence they claim, therefore the warrants can't be valid.
And what would happen though? I mean, like, we've seen high profile cases recently thrown out. We've seen a homicide case thrown out over these things. I mean, I don't know.
Janet just said WSU security notified MPD of Brian and his car on 11/29.
And I think that tip, like that to me is a little bit crazy. So the tip goes into the tip line, and so there was a delay in finding it. But then we hear from other people that there are other reports of people reporting that car. Like one of them would be the private driver. He lived like 1,200 feet from Brian and reported the car. I wonder when he did.
Yeah.
And I don't know. It seems like pretty important if you've seen a car in the vicinity and you've looked up the person and they match. I mean, you would think that would go above and beyond the general tip line. You know what I mean?
Yeah.
Like, you think, I mean, if I have that, I'm just thinking, I mean, I feel like you would hand deliver that tip to you guys are looking at the mantra. Here's this person. This person matches this description. That's the other.
It feels like they've fumbled this investigation, pretty much almost all the way through it. That's the way it feels to me. It feels like they fumbled the ball. I mean, they say they got the person that did the crime, but at the same time, how would you let him drive 2,500 miles across the country if you think he's the person? Wouldn't you pick him up there in Pullman instead of letting him go drive across the country? Isn't that fumbling the ball a little bit?
It depends on the dates. I mean, when Paul, like, I don't know. I just think it's nothing we can determine quite yet. I mean, when Paul says up here, well, I'm just trying to see. Paul said the 19th of December. So it's like, okay, well, if they don't, so he said Brian in the car. Wait, it says Brian obtained. Okay. How did the officers know if Brian and obtained warrants and the investigating officer knew of him starting investigating the car till the 19th of December? So if they didn't know about it until the 19th of December, I could see not calling him for questioning. But think about like all the people they cleared
so quickly.
And then they submitted DNA samples as well. So I would think that if they did know about him on the 19th, they could still ask him to submit a DNA sample. And then you think about when he got back to Pennsylvania, why wouldn't they just question him? If it was the 19th and it was 4 days after they had left, well, then on the 19th, why don't you call someone in for questioning or try to have them come in or ask for a sample of their DNA at that time? I don't know.
I mean, because if you look at it, Kiki, according to the PCA, you had these two security guards, or these two MPD officers, that was working security there at WSU. She said the WSU, the officers. You had one that was searching through the little book, that found the Elantra, and showed that the Elantra was registered there in Pennsylvania. And then an hour later, you had a different WSU officer go out and look for the Elantra. And then when they found the Elantra, it was registered to Washington, and that was November 18th. When they found the Elantra, because it stated that Brian had switched the tags from Pennsylvania to Washington on November 18th. If they were looking at this guy before December, say in the month of November, like Janet said here, WSU security notified MPD of Brian and his car on 11/29, and he didn't leave for Pennsylvania until the 15th of December. So they could have had him come in for questioning and DNA testing and all this stuff before he left for Pennsylvania. If they're looking at him in the month of November, why did they let him go across country if they were already looking at him in November? Before he even left for his trip, because you had those two WSU officers that pegged his car on the 18th of November. And mind you, that was what, about 7 days after the murders that they had his car, and they had his car ID'd there at WSU. Even with the supposed cameras and everything else that caught his car, they were like standing and looking at his car and looking at his tags on the 18th. So why let him leave?
I have no answer for you. And you know what I'm trying to do? I was just looking in the chat. Nina's just took off, but Nina sent me a bunch of screenshots. I don't know if you're interested in me pulling some of these up. You might be interested in what she brought some things up on illegal search.
Hey, Lucky. Unfiltered Lucky's here.
Hey, Lucky. Thanks for joining us. Oh, AR is here too.
Hey, AR.
Let's see what she sent. So here, let me bring this up. I'm just going to bring each of them up in order. All right.
Thank you.
What was that?
I was going to talk to Lucky. Thank you for watching and dropping in the chat and saying hello.
Yes, thank you for stopping by, Lucky. And I hope everybody had a good Thanksgiving. AR in the chat and everyone here. All right, so this first, let me make sure you guys can see that. I don't know if I should zoom in. This first one says Constitution of the United States, Fourth Amendment. The right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrant shall be issued, but upon probable cause supported by the oath or affirmation, and particularly describing the place to be searched and the persons or things to be seized. So that was her first one. Let me pull up. I'm going to look at these first. I want to find the next one. Okay, this is a good one. This is your Fourth Amendment rights. Let me pull this one up.
Okay.
All right, so this one's the fourth. The Fourth Amendment prohibits, oops, this is like really zoomed in. Back up a little. There we go. The Fourth Amendment prohibits unreasonable searches. If a judge signs a no-knock warrant, it's because someone has given evidence under oath that convinces the judge that the circumstances are such that not only is the search reasonable, but also that it is necessary to break into the place to be searched unannounced. I don't know. Okay, so this is the law. I guess my question is, why do we do this? Like, if there's an alternative option, shouldn't we take conservative measures before we? I mean, I don't know. I understand the element of surprise, but you'd think you could still have the element of surprise even without the no-knock execute. It just seems when you're dealing with a house where there's 4 people inside that aren't involved, and time isn't of the essence in any other circumstance. Like, not why is time of the essence at this point? And I would think that getting someone when they go out jogging or they're going to get their car worked on is almost as, good as surprising them as the middle of the night. But I don't know. But I thought that that's really smart. I mean, that at least tells us that's the law. You get a no-knock warrant. That's what happens.
Yep.
And then I had another probable cause one. Let me pull this one up for you. I can't see. Is Nina in the chat still?
Yeah, Nina's in the chat.
Okay. Good. I'm glad she's seen where
She said, element of surprise, no chance for taking hostages, grabbing weapons.
I know, but you know what? I'm specifically referencing, the fact that he was going out jogging, and I get the point of the no-knock warrant. I mean, there's no question why they have it, but my question is, why is it always that way? Like, why isn't there enough? Why if the suspect is like, maybe this is for a suspect that never leaves their home or something, or they need to get in and I don't know, but maybe it has to do with there could be somebody else like assisting in the crime. I don't know. I'd love to hear your thoughts.
Hey, Lucky, would you like to come up if I drop a link? But yeah, I mean, just this whole thing is like a conundrum. Yeah, because with the videos that I showed. Clearly, and Taylor is stating that Brian's Fourth Amendment rights were violated. At the same time, it's just like mind-boggling that all this stuff is going on. In this case, at all the same time, and it makes your head swim.
Yeah, there's so many elements to discuss too, because when you're talking about the Fourth Amendment rights, we don't 100% know everything that's going to be presented as far as the IGG. And that's one of the questions when it comes to obtaining the probable cause and obtaining the search warrants is, you have to be, in this country, you have a right to face your accusers. And so that's part of your Fourth Amendment rights is seeing those things. And we were talking about, because there's no real legislation garnering the IGG, they go with DOJ guidelines. It's becoming a big problem in other cases, not just Brian Kohlberger, but just in cases where, say, for example, if somebody was offered a plea deal. They were facing, hypothetically, somebody was facing, 25 years in prison for a crime they committed, and their IGG was used to obtain the person. Well, in the process of the plea deal, you're still in the hearing phase. So none of the evidence has actually been vetted and presented in front of a judge that's going to be presented in front of a jury. But yet, law enforcement can take that IGG and they can use it against you to persuade you into a plea deal. So there are definitely people out there who they don't know if the IGG was on the up and up. They're just using the good faith exception or the good faith clause, saying that they believe that law enforcement in good faith would have done this. But the fact is there are people who accept plea deals every day based on this information, and there is no legislation on it. So I do think that's a Fourth Amendment issue. You have a right to face your accuser in the United States. And so if you're being offered a plea deal, I don't know, it doesn't seem fair. And so if there was a mistake, there could be people walking around, or there could be people who took sentences in jail and they really didn't have any evidence necessarily against them, hypothetically. I just want to bring that up too.
I mean, yeah. I hate to hear that, brother. Yeah, I'll still support you off the platform too. Yeah, Kristen, I don't really have any plans to return to YouTube. That's AR.
I hate hearing that. I can't wait to talk to you more about that off the scenes, because your perspective is so needed on YouTube. And anyway, that's the first I heard of that. And please, you guys, go visit AR's channel and give him some love. We don't want him to go anywhere. If anything, take a break. AR, if you didn't know, I'm taking a break after tonight too. I'm gonna take some time and step away from YouTube as well. I just think it's appropriate. What are you bringing up here? Suppression?
Yep. And we got Angel D.
Hey, Angel D. Oh, Christy says, you all can't leave us. Well, I appreciate that, but I really do want my content to always be about my viewers and my audience. And my energy is really low and I'm burnt out. And I just feel like I want to do better for my audience. And it's time for me to just step back and take a break and, just stop getting. I just want to focus on my content, and I think it's the best thing for my audience. So, but I will be back, and I hope AR feels the same way. I don't want him to.
Yes, you see, just like it says here in the argument, the affidavit submitted in support of the application for the issued search warrant recklessly or intentionally omitted material information. The Fourth Amendment states ambiguously that no warrants shall issue but upon probable cause, supported by oath of affirmation, and particularly describing the place to be searched and the persons or things to be seized. Probable cause exists when given all the circumstances set forth in the affidavit. There is a fair probability that the contraband or evidence of a crime will be found in particular place. For a search warrant to be valid, the judge issuing the warrant must rely on an affidavit or affidavits sworn to before the judge or by testimony under oath and recorded that establish the grounds for issuing the warrant. Any discrepancy between the items for which there was probable cause and their description in the search warrant requires suppression. It is clear that the issuing magistrate himself, if he is to fulfill the constitutionally mandated function of interposing an independent intelligence between the law enforcement officer and the citizen, must actually and in fact draw the inferences from the evidence presented to him. It is for this reason that the courts have insisted that the full facts from the with the inferences might be drawn and information necessary. The reliability be placed thereupon issuing magistrate. The challenge pursuant to the section of the motion is separately laid out. Mr. Koberger's motion for hearing pursuant to Franks versus Delaware, the motion and to properly the incorporated but not repeated herein.
Okay, so hold on, Robert. Can you? What is the exact title of this doc? I just want to make sure I have the right title before I start talking. It says at the bottom of the page.
Motion to suppress search warrant for Mr. Koberger's person. So this is another search warrant we're talking about.
I just wasn't sure if we were talking about. It sounded like when you started saying that, I wasn't sure if it was the motion for the Franks hearing. But this is really interesting. I do remember Andrea Burkhart saying something really interesting too. When we keep thinking, or not we, I keep thinking when I read this motion for the Franks hearing that it all revolves around the IGG. Obviously, I had that, conversation a few minutes ago, but she seems to think this has a lot to do with Cy-Ray. And I think that's really interesting because lately we've heard a bunch of different creators talking about Cy-Ray and his silence, and does it mean something in terms of the case against Brian Koberger? We also know that on the 6th, the prosecution was supposed to hand over the rest of discovery, which included metadata. And then we weren't sure if those dates had been vacated because of the change of venue, but it looks like a lot has been handed over. But it does sound like Andrea Burkhart was under the impression that a lot of this is going to be the information that Cy-Ray has put forth as an expert witness, saying that Brian Koberger wasn't there. And you see it in some of the language that I was reading in these new documents where they talk about they say the state says Brian Kohlberger turned off his phone, but we are suggesting that Brian Kohlberger had his phone on and headed south. So you can tell there's going to be a clash of reports or interpretations on the stand. It's already been, it always feels like it's being alluded to, and maybe it'll just be in the Franks hearing. I don't know.
Yeah, yeah. I mean, we can all hope that it's going to be in the Franks hearings.
Because it sounds a lot like what we're hearing now, reckless. He used the word piecework. He used the terms, he said inaccurate. He said, said that the work exonerated Brian or proved that he wasn't in the area. I mean, there was, I'm trying to like play in my head the different things that he said during his testimony, but a lot of it, like the things I just mentioned, were reiterated in these new documents. So yeah, Andrea Burkhardt's probably picking up on that, hearing his testimony and then hearing some of the same language.
Let's see.
Oh, it's turning to the chat.
Well, see, yes. You know, just like here, it states that a Pennsylvania law enforcement search warrant lacked probable cause. Now, do we know if the Pennsylvania law enforcement lacked probable cause?
That's $1 million question, right? We still don't know how they got to BK. That's the number one answer.
Yeah.
And so we have this illusion, and whether it's because of what we're seeing, whether it's because there's the gag order, whether it's because Anne has been successful at this point in showing us some reasonable doubt here. We don't know how they got to BK, and it does have this appearance of, from what's been presented to us, some sort of construction of that pathway. And so, yeah, it does feel like you were working backwards, but we do know we don't know everything. And I just go back to, I watch a lot of Peter Trago's Lawyer, and the last time I saw him reviewing this case and like reviewing all the new documents, he said, even as an attorney, he's not going to say Brian Kohlberger looks guilty or not, because he knows that he knows nothing about that evidence, and he's not going to know anything until the trial starts. Like, there's no way of knowing. We don't even know what's going to be presented for evidence. Obviously.
Oh yeah, I know. I mean, we don't know what's going. We don't know what's going to happen. But the trial doesn't start till till August of next year. So we don't know what's going to be presented. We don't. Basically, we're not inside looking. We're outside looking in. Yeah. So we don't know exactly what's going to take place in this trial next year.
No, we're all at the edge of our seats, and we have so much coming up too, because we know there's going to be hearings in January where we're going to hear a lot of these things, and we're going to start hearing about I don't know if we actually will hear about this, because maybe they don't want to taint and put impressions on the jury pool, but they're going to be talking about what the jury can and can't say in open court in January. They're going to make final decisions on all of this discovery in January. And I wonder what we're going to see. I wonder what's going to be sealed and what they'll actually allow us to see. It's so nice to see.
Yeah, that's going to be, that's going to be very, very interesting. And I mean, even the case is, Dylan and Bethany, are they going to testify? Wow. That's the big thing. Is Dylan going to testify next year, or is Bethany going to testify? We won't know until the trial date.
Well, can I ask you, do you think they're going to testify?
I mean, on all honesty, possibly, Dylan may testify, but I don't know about Bethany testifying because we don't technically know what Bethany saw that night. I mean, we still hear about, the naked man thing. She saw a naked man right past her bedroom window. But, we don't know if she's going to testify or not. I mean, if she does, she does.
I can't see, and maybe it's my lack of like covering other cases, but from my impression of this, I can't see a circumstance where either of those girls won't be testifying. I don't know, but I know Dylan, or I guess we should call her Dan, but we know she's in the probable cause affidavit, so
Yeah.
they're gonna state what she saw, and whether all she has is the term bushy eyebrows or there were other things, I cannot see Dylan not being a witness. And I also think that some of the confusion in the PCA and some of the appearance of maybe throwing under the bus was not saying everything she knows, maybe, or keeping her protected. I don't know. And then as far as Bethany, I think we have clear indication she's going to be testifying on the stand. I mean, we've read what Richard Batanti had to say. He was pretty bold about what she had to say could be exculpatory. And it could be something as simple as she saw a naked man and DM saw one clad in black. I mean, 12 gauge says that. It could be as simple as that. And but it also could be the rumors that we heard. And if you remember, or those who've been following this case for a while, they remember some of the rumors, such as what she heard upstairs. She was under the impression it might be the spillover from a frat fight that had happened earlier. We heard that she might have heard multiple people's voices. We've also heard things in her testimony, because we've done a lot of questioning about the 8-hour time delay and who discovered the bodies. In those same rumors, it was stated, and I'm specifically referring to the Mirror article, that that Bethany might have been the one to discover the third floor roommate. So all these questions we have, which we're not going to get any answers to, but if the question, if I think that those roommates are going to testify on stand, I absolutely think so. And I think even though Bethany fought coming back from Nevada, I think a lot of it had to do with she was called as a defense witness. So, and then we know that whole thing got thrown away because they weren't going to do whatever they were called, and they were going to do the pretrial hearings instead. I'm sorry, I don't know the legal terminology. But there were some good comments in the chat. I was just, there's like, I have to go up. Oh, they're talking about Thanksgiving. Hold on. Okay, so yeah, Nina, that's what I was looking at.
Nina said SERT of Pennsylvania was required to do surveillance and their own investigation before a high-risk, no-knock nighttime search warrant approved. Now, was that a nighttime search warrant or a no-knock arrest warrant? Because that's all we hear about is the no-knock warrant. But was that a search warrant or was that an arrest warrant?
I don't know. This SERT of Pennsylvania is required, which is like a team. Nina had sent me an article on these guys. They're like the team of guys that break in and do this. And like, this is what my point was earlier, and it probably got lost in my word salad. But the point I was making is that it's not necessarily that they did this wrong, this no-knock warrant, because that's what they're required to do for all the reasons we read in your last comment. My question is, why is there no exceptions to this? Like, if we have these known reports being able to collect someone, and I'm sure there's a good reason, like, I know element of surprise was one of the things we just read, but it just seems like you're putting a lot of people in danger, or probably the danger of actually having a gun fired if you break in when there's other people there. I don't know. The other thing is too, is if the other people living in the home, they're scared might be an accomplice maybe they want to surprise them so they're unable to do anything. I don't know how it works, but I don't know why they go to those extreme measures if they can apprehend somebody when they walk out the door. This wasn't someone like a recluse in their house. He was all over town from what we understand.
And just like Nina said, they had an arrest warrant for fugitive justice, search warrant for house, search warrant for car, and search warrant for person. But yeah, now I read through the motion to suppress for the search warrant for person, and it was Blaker who filed the search warrant for person. It wasn't Pennsylvania. It was Sergeant Blaker who filed that search warrant to search Brian Koberger's person.
I mean, and then it just, when we hear those different law enforcement agencies brought up, you wondered then again too, why, when you see those timestamps, why they all are the same. And then we go back to that original video we were watching where they were talking about how you don't cut and paste and do your search warrants like that, but you see all these search warrants with the same timestamp, but there's like a 4-hour time difference in between them. It's weird.
Yeah, I mean, yeah. Oh, who was it earlier? I think it was Tonka said that all these different narratives piling on top of each other is like a conundrum. And it is, all these narratives are a conundrum that's piled on top of each other.
Yeah, Tonka had, I'm going back because Tonka had another comment up here. I just wanted to find, but back to the dates. I wish I could star some of these comments here. Well, I don't know, Robert. I turned to the chat. What do you guys think? Do you think this search warrant is going to get thrown out? I mean, Anne's argument was 2,000 pages, and that since has been revised. I haven't been on the Idaho Judicial Cases of Interest website in like 48 hours. Have you seen any new docs, Robert, in the last
I actually got it pulled up right now.
The 26th is the due date,
and no, the 26th was stipulated motion to seal. The 22nd was the Frank's motion. The 21st was the state's response to defendant's 6th motion to compel discovery.
I was thinking the 26th was the date she had to have the revised version of that 2,000-page document resent. Anyway, my point was, I wonder if something had been filed, and I didn't know if we could see it at this point. So.
No. Oh, okay. Motion to strike memorandum support and motion to suppress. Which one do you want to see? The newest one? You want to see the Frank's motion?
Yeah, definitely. I mean, that's our most important document right now. I feel we're focusing on. Everything hinges around that. Wait, Alex says she technically has 7 days before trial.
Okay.
Okay. Right.
Before the court is defendant's motion for Frank's hearing, November 14th, a memorandum in support of motion for Frank's hearing. Accompanying the motion are 38 exhibits. comprising over 2,000 pages. Unfortunately, defendant's memorandum largely fails to identify with particularity the relevant portions of the exhibits, instead referring simply to the exhibit number without identifying the precise pages at issue. Thus, the court is left with the unavailable task of sifting through pages and pages of largely irrelevant documents to ascertain what portion defendant may be referring. The court is not required to search the record looking for evidence. Consequently, if defendant wants the motion to be considered, he must file a revised memorandum identifying the relevant portions of the record by page number and line number if referring to testimony. For the facts asserted, in addition, defendants must resubmit his supporting exhibits to exclude portions that are not relevant to the motion because the state is under a deadline to respond. The court will allow defendant until Tuesday, November 26th to submit the revised filings.
Wait, can you present that one more time? Can you just pull that doc back up? Yeah, so the 26th, I thought that was it. So the deadline, so the 26th to submit those revised filings. So I mean, she must have resubmitted it under seal and we can't see it. But then Trish has this comment right here. It says, do y'all see at the bottom of that, Ashley is the only one under the state signature? I thought.
Well, this says Judge Stephen Hitler.
Oh, that's okay. I think it was maybe the motion to suppression before. And then under that, Tonka says the most relevant part. Wait, the most relevant part of the case is. Wait, the chat keeps moving. Case are very conspicuously missing. I think the Franks hearing will go forward. And honestly, when you hear what those videos were just saying, they do this for accountability, and it does go back to the judge. They do hold people accountable. And the judge has a right to contact the other judge and find out why they signed off on it too.
Yeah.
Oh, so sweet. I love the comments.
Echo said, not that one, sorry, the other one, the one that Ann resubmitted.
And Nina says she made the deadline request to be sealed today. I wonder what their arguments are going to be straight. Oh, I mean, of course we're not going to hear what the arguments are, but Andrea Burkhart thinks that it's leaning more towards hearing about how they tracked Brian. But we also reference IGG. Is it going to be both? And what happens if the Franks hearing gets granted? What happens if they throw these search warrants out? I mean, it doesn't throw the arrest warrant out, or does it? And what did Bill Thompson mean by if things get thrown out? Because he did reference if this day came. And
yeah, he did reference that, and I did find what she was talking, what Tricia was talking about. Let me get pulled up real quick. Right there, Ashley Jennings, Senior Deputy Prosecutor, Ann C. Taylor. And Taylor, attorney at law. So, why is Ashley the only one that's mentioned? Where is Bill Thompson? Is he going to retire? You're muted, Kiki.
So Trisha was just reiterating in there. She said, "Yep, that's the one," and Bill's name's not on it. And And now it has BT title.
Yep.
So much is going on there too. But
yeah, there is. There's a lot going on in this case. There really is.
Oh, and I am I'm hoping that they subpoena Bill as a witness. Are you being summoned? Have we taken too much of your time tonight, Robert?
No, my daughter's sitting here just mesmerized at the Christmas tree, going, "Daddy, why is the Christmas tree white?"
I said the mini ornament missing.
Okay.
I need to add tiny ornaments today. Like the mini ornament.
Yeah, I know the mini ornaments.
We need to add those.
Okay. She wants mini ornaments added to the tree, even though there's no more room for ornaments.
Oh, she's only a kid once. Just figure it out.
Yeah.
I do like Trisha says, so she says that literally is BT's title. And she's talking about under Ashley Jennings' title, it says Senior Deputy Prosecutor. So
Yeah, because I mean, if you looked at it at the hearing on the 7th, Bill Thompson wasn't there. He was watching via Zoom. Yeah, you of course you had Alyssa Jennings and the other two, but Bill Thompson was watching the hearing via Zoom. He wasn't even there.
I mean, they did give them that option, but I couldn't understand that either. It did seem like what an important thing. It's like, was he trying to say that it wasn't important, or like he didn't find the arguments? I don't know what the message trying to be sent, but of all the cases you can make it to, why would the priority be another case than this one?
Yeah. I mean, and you have John Judge, who retired. So is Bill Thompson is he next?
A lot of people retired.
Yeah, Chief Fry, Chief Lanier. They retired what back mid 2023. Of course, Chief Fry retired to run for sheriff.
And Judge John Judge just gave his at the beginning of November.
Mm-hmm.
So I would, you can look at it many different ways. We can also look at it in terms of this case is just incredibly stressful and people are deciding to walk away after being exposed to this. But the other thing you have to keep in mind when you see a lot of people resigning, I mean, because like say this was a company, say it was a corporation, and you saw boom, 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 like chief officers and different people resigning, shareholders or people with interest in the company might be like, well, are they resigning because they see something unethical or something they don't want to stand behind? Because sometimes that's the message you send. So everybody does pay attention when you see a bunch of people retiring. Are we connecting dots that don't need to be connected? I don't know, but it's worth mentioning because you would pay attention if we were talking about a business. You'd pay attention if we were talking about a corporation. So, I mean, it's definitely, it brings into question, or is this just such a high stress case? People are retiring left and right.
Yeah. Angel D just said, Ingrid Beatty and Jeff Nye are super competent in my opinion. I mean, if you look at it, since they did the change of venue, we're seeing a lot more competent people. Judge wise, and then of course like Angel just said, Ingrid Beatty and Jeff Nye are super competent. Yeah, you're seeing basically this trial now that was on a slow track in Latah. You're seeing it now being on a fast track. headed by competent people, a competent judge. Yeah, John Judge, he pretty much laughed and made jokes through half the hearings, did he not? You're muted.
I said, can you repeat the question, please?
Yeah, it just seems like since they did the change of venue, you've got a lot more competent people now in charge of the case. Judge-wise, and like Angel D just said, Ingrid Beatty and Jeff Nye are super competent, and it just feels like when Judge John Judge was in charge of the case, he really wasn't super excited to be in charge of the case.
Oh, I couldn't agree more. So, like, I think about when we think about the May 30th hearings, when we were watching Massaw in front of Judge John Judge, and she kept saying to the judge, he said, I think you're overestimating my power. And she looked right at him and she's like, you're underestimating your power. And she laid out all the things he could do to make this case move along a little bit more. But when we changed it to Judge Hippler's court, it almost like that was almost like a non-issue, because the first thing he did was issue that scheduling order. It laid out the dates, the responses, all the little nuances that would be going on. It really spelled everything out. It put deadlines, it put expectations and goalposts in front of everyone. And then the other thing that I think is really positive for justice in this case is what we witnessed in the DP hearing, which was, even though it seemed like he had made up his mind from the get-go and he had some decisions and arguments already in his head, he said right on the stand, no, I want to hear this argument. I want to know the legality of it. So he's interested, like his mind is in the game and he wants to hear the legal arguments to this. It definitely shows that he's trying to put his he sounds like a good judge who doesn't try to have bias, and he wants to hear the law, the legal arguments. He likes what he does.
Because I mean, if you look at it, his first meeting was, I would say is pleased to meet you guys, but I wouldn't want to come off as a liar.
I'm just wait, say that again.
And if you remember in their first hearing in front of Hippler, and it was, he said, I would say it's nice to meet you guys, but I wouldn't want to come off as a liar.
Yeah, I remember how he said that, and I do think if you're a judge, in cases you'd have a better practice response than that. Oh my God, I'm just looking at the chat. I don't know what they're laughing at.
Angel, he says, "Oh my God, I'm sorry. It's been a while. It's been a while since I was let loose in a live chat."
I know. I'm seeing what they're saying. They just randomly display comments today. He says, "I think Judge John Judge was between a rock and a hard place," and the other thing you think of in that courtroom with JJJ is those parties, Ann Taylor, Bill Thompson, Judge John Judge, see each other every single day and work with each other in all these cases. And it's for me, if there's going to be a change of venue, if that option's going to be there will never be another case so big that this little courtroom would have to make these types of decisions. I do believe, particularly when you see how small of a world it is with all those people, those three entities working together all the time. And even Ann Taylor saying she's a regular inside of Bill Thompson's office. And I'm not saying she isn't still now, but just knowing they work together, I just feel like having a third party, having a bigger venue, not only is it the right thing to do, but if you're gonna do it, what other case would you consider it if not this one?
Well, we've been live for almost 2 hours. Why don't you stick around, Kiki, after the live? I'm going to go ahead and end the live stream.
Can I, do you mind if I just say something really quickly?
Go ahead.
Thank you, Robert. I appreciate it. So I just wanted to take a minute and talk to the chat. I know we don't have a lot of people here, and I just want all of my viewers to know that I'm going to be stepping back from YouTube for a little while. Not a long time, but I'm just taking a break. And there's a few different reasons for that, but primarily, if I just want to be honest with my viewers and be perfectly honest, my energy has been really low, and I think a lot of you have followed me know that I've had some, without revealing, without talking too much, I've had some stressful situations, and I just want to take a moment back so that I make sure I'm representing my channel and my viewers well. And also, I want to have higher energy, and I do apologize. I have had a lot of reactions to negative comments and negativity I've seen around me. And anyway, so I am sorry, and I am taking a break so I stop reacting to these things and get refreshed and get my energy back. And all in all, that's what's important to me, because I've said before, I'm a viewer driven channel, and I am nothing without my viewers. And so I want to put out the best content. And in order for me to do that, I just need a little bit of a break because I'm kind of burnt out. So anyway, I am stepping back for a little while, and I just wanted to say something. And I just, I haven't been my highest self lately. So apologies for that too. But I'll stop there. I love all of you guys, and I can't wait to see you again. I don't know. I'll be helping Robert in the background. That's all, Robert. I just wanted to say something because I owe it to a lot of people to make some sort of statement, because
I know.
I've been running.
Angel D just said, "I will miss you, Kiki. I'm taking a break from this case too." Then Christy just said, "We love and stand behind you, and we'll be here waiting for you to come back. Enjoy your time off of YouTube."
Yeah, and I appreciate you guys, all of your kind wishes, and I also I plan to come back as a better creator with more patience and more tolerance for everybody in the true crime community.
Yeah.
And also, no matter what, I mean, we all know there's always drama or inner workings behind the scenes, and it's really important that that we don't feed into that. And anyway, I should probably stop there because I'm like repeating myself, but at least everyone understands where I'm at. And I appreciate you standing behind me, and I hope that you would stay subscribed to me while I'm
Angel D says, "It's not goodbye, it's just farewell."
I hope the same is for AR too, after what I read tonight.
Angel D says, you may need to keep people at arm's length. Kiki, keep your core team close.
Appreciate the advice, Angel D. Keeping people at arm's length is important, but what's most important is that we shouldn't have to, we should all control our reactions, because we can't control what other people do. All we can control is our reactions. And the fact is sometimes you don't know everything. Even though I might think I know an entire situation, I might be wrong. And so I have made mistakes in reacting recently. And it's best if I just take a little time back and step back, and I'll see you guys a little bit, and I'll stop talking, Robert, so you can end the show.
Okay. I'm not going anywhere. Love Tina. Tina said, wishing you guys, wishing you good rest. Thank you. I will miss you guys and be waiting for you to come back. And I told her I'm not going anywhere.
No, you
But all right. I want to thank you. I want to thank Kiki for coming on tonight, and I want to thank everyone for tuning in. And this is Robert with True Crime Podcast, and we are out.
Stillness where the silence falls, echoes of laughter haunt these walls. Memories linger like whispers in the night. Every corner feels empty without your light. A heart once whole, now shattered and torn. Every day feels like the calm before the storm. Chasing shadows of the moments we shared. In this world of sorrow, I'm lost and bare. A heart once whole, now shattered and torn. Every day feels like the calm before the storm. Chasing shadows of the moments we shared. In this world of sorrow, I'm lost and bare. Shadows of goodbye.